I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introductory lesson on New England state courts. This lesson is the latest of many provided by NEFAC that explore state freedom of information laws. We want you to know how to access government information, and these lessons are the best place to start. If you haven't already, please check out our classes on state public record and open meeting laws, as well as the Federal Freedom of Information Act. Each class builds off one another, and they all collectively provide a curriculum you won't find anywhere else. All lessons are at nefac.org/FOI guide. They're also on our YouTube channel, 5 Freedoms. Before we begin today's lesson, a special thanks to everyone who is helping us make these classes happen. The Society Professional Journalists Foundation, SPJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe and the New England First Amendment Coalition, and I want to thank you all for joining us for this webinar, which is brought to you by the New England First Amendment Coalition. Now, this session is going to focus on the state courts in Connecticut, and with us is attorney Bill Fish, who's a partner at Hinckley Allen, and he's going to give us a general overview of how the courts work in Connecticut. Bill, thank you so much for being here.
Thank you for inviting me back. I really appreciate it. Let me start by just giving a quick intro. I'm going to talk about, as Emily said, the court structure and organization in Connecticut. And then I'll talk a little bit about accessing court records and also court proceedings. So an overview, in Connecticut, there are 3 state level courts. We have the Superior Court, an appellate court, and then the Supreme Court, with the Supreme Court being at the top of that hierarchy. Before you get there, we also have a probate court system, and it's a little bit separate and different from the state 3 courts that I just mentioned. The probate court system, historically, each town had their own, and now we have maybe 50 or so districts in Connecticut, and different towns will elect probate court judges for the probate court. And if you don't like a decision in a probate court, you can appeal it to the Superior Court and start your way up the ladder. That's the state court system. I'm going to focus mostly on the Superior Court, the appellate court, and the Supreme Court, but I wanted to mention the probate court. And it handles, much like it sounds, issues relating to wills and trusts and things of that nature. The Superior Court is the main trial court in Connecticut, and it will hear contract actions. It will hear all sorts of different actions around the state. We have 13 what are called judicial districts in Connecticut, 12 geographic areas in Connecticut, and we also have 12 juvenile districts. Let me explain a little bit about what each of these are. When you look at the Superior Court, since it's the main trial court in Connecticut, it has 4 separate divisions. We have the civil division, the criminal division, a housing division, and a family court division. Let me start with the first one there, the civil court. And that's where most of the non-criminal action will take place. And if you're looking to access a trial or access court civil records, this is the area of the Superior Court that you would want to focus on. The Superior Court, as I said, has civil, criminal, housing, and family. So if I start with civil, the civil court itself is divided into more subsections. There's an administrative calendar, a jury calendar, a non-jury calendar, a small claims division, and a summary process. Now, this all may sound confusing, but it's important if you're looking to access a particular proceeding or records pertaining to a particular proceeding, you need to know which part of the Superior Court system that you're looking to access. If you were, for example, looking to get records about a breach of contract case that was pending, that was a big deal, and you wanted to see those records, that would be in the civil division, and that would be in a judicial district. And if it was Hartford, as for example, where I'm sitting, and you can see the Travelers Tower behind me, you would go to the Hartford Judicial District Courthouse for that. I mentioned geographic areas, or what we fondly call GAs in Connecticut, and that's where much of the criminal work is done. If you're in the criminal court, having been charged with a misdemeanor or a felony or something of that nature, that would be in a GA system. And the judges don't go from one to the other very often. If you're a criminal court judge, you tend to remain a criminal court judge. But these are different courthouses. So if you were looking at getting access to a criminal case, you would be likely going to a GA courthouse as opposed to a JD courthouse. And that can get a little confusing because Hartford, for example, has both a GA and a JD. And so you would need to know the difference in where your court case that you're focused on is pending. There's a housing court, and this sounds exactly like what it is. It's a court dealing with issues pertaining to leases, but it can also include commercial leases. So if you're the landlord at a mall and you're leasing property to a Bed Bath & Beyond, for example, which just filed bankruptcy, that would be in the housing court alongside a lease for a small one-bedroom apartment that might also exist in focusing on Hartford and Hartford. There are separate courthouses for the housing court in Connecticut, but only in the bigger towns or the bigger cities. So that'd be in Hartford, Waterbury, Stamford, New Haven, places like that, where there is a separate court dedicated just to housing. And that's because there's enough caseload there that you need the extra court, the extra clerk system, the extra courthouse. If you were in one of the smaller judicial districts, you would be in the regular civil courthouse where they combine it all together. And then the final division within the civil court is the family division. And that does exactly what you would think it does. It deals with divorces, deals with child issues and whatnot. Another division, it's in the judicial districts, but it's a separate set of judges who deal and are skilled in dealing with family law issues. So if you were going to a family court case, you'd be dealing with a judge where he or she is a regular judge in the family court and doesn't, for example, do the criminal side or the regular civil side. So that's a high-level overview of the Superior Court in Connecticut. And as you can tell, it does most of the day-to-day kind of heavy lifting. There's one more excuse me, piece of that I want to mention, and that's called a complex litigation docket. And again, it's much like what it sounds. If you have a particularly complicated case that's pending in Connecticut, you can ask, it's discretionary, to have it transferred to a complex litigation docket. And these dockets exist in the Hartford, Stamford, and Waterbury judicial districts. But even if your case is pending outside of those districts, you can still be transferred to this complex litigation docket. They have their own separate system there. And there it's assigned to a single judge, and he or she will hear the case from the beginning to the end. It's important to know that because if the complex cases are ones that tend to be, by the word, as you can tell, more complex, and therefore they may be of more interest to people, and you would need to go to the complex litigation docket in order to hear about these. So again, that's an overview of the Superior Court in Connecticut that does most of the heavy lifting day to day. And now you get to the appellate courts. And in Connecticut, as I mentioned earlier, you have the Supreme Court, which is the top level court. There is not, with some rare exceptions, a right to appeal directly to the Supreme Court. Instead, if you are unhappy with the decision of the Superior Court, you do have a right to appeal to the appellate court. And that's an intermediate court that hears appeals in Connecticut, does not take evidence like most appellate courts around the country. There are 9 judges on the appellate court. And when you take an appeal to the appellate court, the parties write briefs, and then typically 3 judges are assigned to the case. And that 3-judge panel will hear argument and then decide the matter. If you go to the Supreme Court, there are 7 justices on the Supreme Court. At the moment, we only have 6 because one of the justices was fortunate enough to go to the Second Circuit. And so we're waiting on the governor to appoint and have the General Assembly confirm a 7th justice. But the Supreme Court is a place, if you're unhappy with a decision at the appellate court, you can ask the Supreme Court to take certification of your case and then go to the Supreme Court and have the Supreme Court decide the matter. And that is putting aside a rare appeal to the US Supreme Court, kind of the final word on the matter. Just as a quick plug, I'm on the board of the Connecticut Supreme Court Historical Society, and if you jump on their website, you can learn a lot about the Supreme Court. We have a long history in Connecticut, and there's a lot of fascinating stuff. So let's talk records and court access. And if you've taken the time to watch any of the other videos on our sister New England states, you know that there's a First Amendment and common law right of access to judicial records in probably all of the New England states, would be my guess. I haven't watched everyone, but that is to be distinguished between public record laws. So every state has a freedom of information or sunshine law, but those laws in Connecticut do not apply to court proceedings or court decision making. Rather, in order to get access to those records, you need to have a different set of rules, but at the end of the day, they kind of take you to the same place. You get access to most things that are judicial records in court. And there was a case a few years ago where I had the good fortune to represent the Hartford Courant. Another lawyer from Boston was involved representing the New York Times. And in that case, the Connecticut Supreme Court laid out the law as to why the public should have access to court records. And if you let me just read quickly, it's so important, the words are so meaningful, a short excerpt from the case. It says, the Supreme Court said, public access to court documents traces its roots back centuries through the common law, stemming from the practice of open trials. In the days before the Norman Conquest, we are going way back, public participation at criminal trials was an inherent part of the court system, as the freemen of the community who represented the patria or country and were required to attend were responsible for rendering judgment at trial. Over the centuries, trials remained open, and those not in attendance could be assured that community standards of justice and procedural norms would be enforced by those present. The tradition of open trials made its way to colonial America and has evolved into a presumption of public access to court proceedings and records that remains a fundamental part of our judicial system today. The rationale underlying the presumption is straightforward. And this is important. Public monitoring of the judicial process through open court proceedings and records enhances confidence in the judicial system by ensuring that justice is administered equitably and in accordance with established procedures. It took the time to read that because it really underscores why both the common law and the First Amendment provide access to records in Connecticut. And Connecticut has an interesting little history here. There was a time in the early 2000s where it was discovered, and this has been going on for years, that there were secret court dockets in Connecticut. You know, this might be in the family court where two well-positioned, important people were getting a divorce, and it wouldn't be on the docket. You wouldn't even know it existed. So you forget getting access to the records. You could even access the case. And there was a series of well-known disclosures and then a lot of litigation involving the Hartford Courant and others that went all the way up to the Second Circuit Court of Appeals. And as a result, it was determined that this was a violation of the First Amendment right of access. And in response, giving Connecticut the credit that it's due, Connecticut amended the practice book, which are the rules that govern procedure in the court system in Connecticut. And it put in place two sections in the practice book, one for civil and one for criminal. And they're very similar, but they put in place these two sections to make it crystal clear that we have this right of access to court records in Connecticut. And the two sections are worth noting, and I'll repeat it twice. The first one is 1120 capital B in the practice book. So it's practice book section 1120B. And I'm sorry, 1120A, I misspoke, 1120, capital A, not B. And that section lays out the presumption that the Rosado case that I read a minute ago made, that court records are open to the public. Now, it's not all court records, and this is important to understand. In civil cases, there's often discovery that the parties exchange. I ask for all these documents that you have, and the other side asks for all these documents that we have. Many may be completely unrelated to the case, and the parties exchange discovery. Those are not judicial records unless they get filed with the court for some matter. So if the two parties are privately exchanging discovery documents, those records are not judicial records. And this First Amendment right of access that I'm talking about in the practice book codified does not apply to them. Rather, it applies to records that are on file with the court that the clerk's office would have. And so if you look at 1120A, it says right in the beginning that there's a presumption that documents filed with the court shall be available to the public. It goes on to say that you can seal a record, right? If you want to make up a great law school hypothetical, there's litigation going on in Connecticut with the formula of Coca-Cola, right? A top secret thing. And just because that's filed with the court doesn't mean that the public would all of a sudden get to see it. Rather, it would almost certainly be sealed so that only limited people could get that. And there are other circumstances where judges can seal records, perhaps to protect the name of a rape victim in a criminal case, the name of some other witness whose safety may be an issue. Those things can be sealed by a judge, but it's really important to know that in order to do that, the judicial authority has to conclude that the order is necessary to preserve something that's more important than the public right of access that the Supreme Court articulated and that I read to you. And at the same time, there's nothing else that's more limited that the court could do in order to protect that information. Only then can a court seal a file. And remember, this was all done in response to these super secret dockets that Connecticut had going on for years. Now you can't do that. Not only that, if you're going to seal a court file in whole or in part, you have to give notice to everybody. And there's a special notice procedure. So if you're monitoring a case as a reporter or somebody else, you actually get notice that the court or party to the case is looking to seal some aspect of a particular case. Now, I mentioned 1120A on civil cases. There's almost an identical section, 4249A. Make sure I got it right. Yeah, 4249A, that deals with criminal cases. And it's the same rule. And it's because when it comes to judicial access, there's really not a big difference between civil and criminal cases in theory. In fact, the US Supreme Court, most of its court access cases over the years have been on the criminal side. And that's, so again, so important. If you don't have access to the criminal cases, how do we know as the members of society, the citizens of the state of Connecticut in our case, that our court system is doing things the right way and that it should be? That is the benefit of having an open access system. So some practical issues. If you want to access court records, whether it's civil or criminal, many of them are online on Connecticut. We have a great online system now. If you go CT case lookup into Google, the judicial system will pop up. There's other ways to get there, of course, but there are different ways to look it up. You can look it up by docket number, which is the number the case has. You can look it up by party name. There are all these different ways to look up cases in Connecticut. Now, you won't get every document that's on file through the electronic docket, but you will get most of the important ones, including court orders and decisions and complaints and things like that. So if you're looking for court records at the Superior Court level, the Appellate Court level, or the Supreme Court level, you're going to jump on CT case lookup and you're going to find most of the things that you're probably looking for, saving us all a trip to the clerk's office. But if you can't, and you want to actually look at the entire file and you want to look at it page by page, you can make a trip to the clerk's office. These are public records, as long as the file isn't sealed. And if it's sealed, the piece that's sealed would be taken out, so you wouldn't see that. You can look at the entire file. If you can do it with a battery scanner because you want to make your own copies while you're there, that's perfectly appropriate as long as you don't interrupt what's going on in the clerk's office. And you can't do anything to leave an imprint or a mark on a document. There are actually rules in the Connecticut Superior Court to that effect. So if you're starting to mess up their court records, you're going to run into a problem. But if you're looking to see a court file and physically look at it, that's perfectly easy to do in Connecticut, whether it's civil or criminal. Now, there are many statutes that change what I just said, like juvenile courts. As probably almost everybody on this webinar knows, if you're trying to get access to a juvenile court record, you're going to run into an issue because juvenile records are generally confidential and sealed in order to protect the issues pertaining to the juvenile. So you will not get access to that. There are other record statutes like that change what I just said about access to court records. Although Connecticut did a good thing when it, in response to that secret docket I mentioned, put in place these practice book provisions. Connecticut, the General Assembly has also done some things that are a little bit not so good. They passed a law a few years ago where they said if you're a juvenile, but you're being tried like an adult in the Superior Court Criminal Division, it's still completely secret. In fact, you couldn't even get the docket information. It was so ridiculous, and I say that having represented the Hartford Courant along with the Reporters Committee for Freedom of the Press. We went up to the Second Circuit, and the Second Circuit said that law was unconstitutional and that you could not do that. So those records are now open to the public. So that's a high-level summary of records. I really encourage you to check out the electronic docket in Connecticut if you're looking for things. Let me just flip briefly to access to court proceedings, because many times it's not just the records. You actually want to be there, listen to the testimony, watch what goes on, see what the judge or the jury is doing. Again, whether it's civil or criminal, we have in the practice book, we have sections that deal with this, and court proceedings are presumptively open. It's very difficult to close a court proceeding, but it can be done. If you go back to my Coca-Cola example, if there was going to be testimony about the formula of Coca-Cola, a top-level trade secret, the courtroom would likely be closed for that testimony. I mentioned the practice book provisions for closing or getting access to records. On the civil side, it's 1120A, as I said. 1120 without the A, so just plain old 1120, is the civil side practice book section dealing with closing a courtroom. So a judge has to consider all the alternatives, can only do it if the particular thing that he or she, as the judge, is trying to keep secret is more important than the First Amendment and common law right of access. And then the courtroom can only be closed if it's the most narrow remedy available, and it can only be closed for that limited purpose. So it's very difficult as a practical matter to close a courtroom. There's a criminal counterpart. The 1120 section in the practice book that I mentioned deals with the civil side. There's a counterpart on the criminal side, that's section 4249 for closing courtrooms on the criminal side. It's the same type of provision, very, very hard to do. And it's rare that courtrooms are closed in the state of Connecticut, fortunately. There's also the ability for the press to come in with TV cameras, and I won't go down that path, but there's a whole set of rules that are designed to deal with how does the press get involved televising particular court proceedings. So Emily, I think I've covered the main points. I don't know if people have had any questions as I've rambled on here.
Yeah, thank you so much, Bill. That was a really good overview. So, yeah, I don't see any questions in the chat. Oh, wait, actually, here we go. Is there any idea why criminal courts in Connecticut not having a electronic court filing?
I don't. There's two different things. You can have access to court records, and you can have electronic court filing.
Okay.
The criminal docket is so busier and is just a more complicated, fast-moving thing to deal with in some ways. And so if you ever gone to like a calendar call for criminal cases, it's boom, 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 trying to move things along. So I suspect it's cost related, but I'm not a criminal lawyer. I'm a civil business lawyer, so I actually don't know the answer to that question. But that would be my expectation.
And can you talk about the rules that apply to case records for matters in which the defendant was found not guilty?
There's a process depending on the particular case to protect those types of records. It's called erasure in Connecticut. So there's a way to have court records erased. They're really not erased. That's a sort of a word for sealing. And as an example, if a record is erased, newspaper articles that talked about the arrest don't get erased or closed or somehow changed unless the newspaper took them offline for some reason. So if you are being charged with murder and you were found not guilty, those records are still public records because the entire process is still a public record. So I suspect the person was asking more about these erasure type statutes. Those would often go along with like accelerated rehabilitation, which is obviously not being found not guilty after a trial. But if someone elected AR and successfully completed the things that you need to do in Connecticut, you can have your court records erased, which means that they're not going to be on a docket system someplace.
Oh, wait, we got more questions. This is awesome. Is Connecticut unique that judges can seal stuff?
No, it's not. In any state that I've been in, the judges have the right to seal court records. Connecticut is a little bit more vigorous than some states around the country in terms of protecting the right of access, in part due to the things we've gone through and some of the decisions that are out there. Should give a little plug to the media because the newspapers over the years have been on the front lines of that battle, making sure that the courts do what I think personally that courts should be doing, which is keeping records transparent to the extent you can. Newspapers fought that fight many times, certainly in New England. But judges always have the right to seal things. There's a whole process that I haven't spoke about today about lodging records, where you submit them under seal, but they don't become part of the court file unless the judge actually accepts them under seal. And if the judge says, no, I'm not taking it, the person submitting it has the option of either taking it back so it's not in the court file and never became a judicial record, or can take it out of the envelope and file it in a regular way, but obviously no longer secret. But judges have that power for sure.
Excellent. And all right, here's another question. Once a stipulation of settlement is signed, are records that have been sealed at the request of both sides unsealed?
If a judge sealed records during the course of the case, it is highly improbable that a settlement would change that. It's possible. I'm sure he could make up an example, but the mere fact that the case settled, or even if it's tried to conclusion, would not, in almost every instance I can think of, reverse the sealing order of the court. Things could happen in a particular case that might cause a judge to do that, but that would be an exception in my view.
Bill, thank you so much for doing this. Really appreciate it.
My pleasure, and good luck with the book, Emily.
Oh, thank you. All right, take care, everybody.
Cheers.